Good evening, everybody. I know, I'm sorry. It's been a long day. My husband and I are currently working on, getting shit together for our impending move to the Pacific Northwest. Here within the next few months, June-ish is when we plan on moving. And, moving our house, moving our family is like, it's on par with Noah's Ark. It's really difficult. We have so many logistics that we need to put into play, and it's really fucking scary. On top of that, we have to find, a place big enough for the home studio and get all that stuff together. And yeah, it's insanity. And make sure that, we've got everything that John and I need to keep things running, keep operations going. So it's been an arduous day, to say the least. But I wanted to take a minute to sit down and kind of, how I've been talking about different legal concepts and giving you guys some basic ideas on that. I wanted to explain the opening statement. Not Kratz's opening statement, the concept of an opening statement and what it's actually for. Because I don't think a lot of people understand it. I've had some people comment, I've had some people talk to me and tell me, you're really kind of hammering hard at this opening statement of Kratz. And what I don't think they understand is Kratz played dirty pool with that opening statement. He really did. Pardon me while I get a bit of vape. E.T. I really love this thing. I'm having a blast with it. So I wanted to sort of give you guys an idea. An opening statement, it's your first contact with the jury where you're not voir diring, or I'm sorry, it would be pronounced voir dire. You're not voir diring them. They're kind of, it's your first contact with regards to the case itself. After jury selection, this is your first real contact with the jury. And it's where you outline what your case is all about. And there are certain guidelines in that. Guidelines that Kratz shat all over. Seriously. There are ethical considerations in an opening statement. Each side gets the same amount of time to sort of present an outline of their case. Ladies and gentlemen of the jury, your honor, opposing counsel, my name is Casey Martinez, and I'm here today representing the state of New Mexico. And as we all know, we are here for a criminal case, blah, 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 it goes on down the line. What you are not supposed to do is state anything emphatically. The defendant is guilty. You're not supposed to state that. Technically speaking, your opening statement can be thrown out because of some shit like that. You're supposed to only state what the evidence will show. Ladies and gentlemen of the jury, throughout the course of this trial, the evidence will prove that no one other than the defendant could have done this because of X, Y, and Z. You see? You can't say, well, that guy's guilty. And Kratz, why the fuck did it take you so many minutes, like a minimum of 2.5 hours of an opening statement to basically say, that guy did it. That's what you did. Part of the ethics of opening statements is a lawyer shall not knowingly make a false statement of material fact. A lawyer may not allude to any matter that the lawyer does not reasonably believe is relevant or that will not be supported by admissible evidence. Now, I'm going to go ahead and refer back to Ken Kratz because that's the case we're working on right now. But when Kratz says in his opening statement, we will show you when it happened, where it happened, and how it happened. These were 3 things that he could not prove. Nobody knows when Teresa Halbach actually died. They can't know that because you cannot get a time of death from bones. Nobody knows where she was actually killed because there is no evidence of such. And nobody can state how she was killed because I'm sorry, but that bullet hole, that's not a fucking bullet hole. I'm sorry. I'm just saying. And I don't trust Eisenberg anyway. I don't trust her at all. I don't trust her testimony. I don't trust what she said about the case. And I don't trust her as a forensic anthropologist. I just don't. Just no. But that's the point, folks, is Kratz stated this like it was fact, and it wasn't fact. And how you can't do that. How Strang and Buting did not object to that, although they could have, I don't know, because I haven't gone through the whole case transcript yet. But they could have, and they should have, and they probably did object to these things. I'm sure Strang and Buting are just loving my ass right now. Like, why are you picking us apart? I'm not, guys. I'm not. You guys are my heroes. Okay. Rule 3.4 is a lawyer shall not assert personal knowledge of facts in an issue. I will let you go ahead and figure out which statements those are. Rule 3.4, subsection E, a lawyer may not state a personal opinion as to the justness of the cause, the credibility of a witness, the culpability of a civil litigant, or the guilt or innocence of the accused. And yet that's exactly what Kratz did. He said repeatedly in his statement, Stephen Avery killed her. Stephen Avery is guilty. And he can't do that. And Judge Willis, by the way, you suck at your job. You're next in my crosshairs, motherfucker. Rule 3.4 also prohibits a lawyer from knowingly disobeying an obligation under the rules of a tribunal, and yet that's exactly what Kratz did. The whole case should be declared a mistrial just based off of his conduct. A lawyer, let's see, although it may sound rather vague, this provision is generally understood to apply where a lawyer intentionally includes an opening statement anything the lawyer knows would violate legal guidelines, and yet Kratz did it repeatedly. A lawyer should not engage in argument, appeal to sympathy or prejudice, discuss the law, which is all Kratz did in that fucking statement, exaggerate the evidence or statement as facts and issues outside the scope of the pleadings, which again, that's all he did. Engage in attacks or negative comments on his or her opponent's case, which again is something that he did in his opening statement. Important constitutional rights are at stake and must be protected. And yet, Kratz repeatedly ignores Stephen Avery's civil rights throughout the course of his opening statement and throughout the course of the trial. Through the whole investigation anyway, but we're talking specifically the opening statement right now. Yes, my hair is very curly tonight. I just noticed that. I was like, oh my God. When I wash it, I tend to just throw it up in a bun with a hair stick and it like gets this shit going on and I'm going, oh my God. My hair is curly anyway, and then you add that into it. Now, as former United States, I'm going to quote this, as former United States Chief Justice Berger explained, an opening statement has a narrow purpose and scope. It is to state what evidence will be presented, to make it easier for the jurors to understand what is to follow, and to relate parts of the evidence and testimony to the whole. It is not an occasion for argument. To make statements which will not or cannot be supported by proof is, if it relates to significant elements of the case, professional misconduct. And again, that is all Kratz did. Now, there are some general do's and don'ts for an opening statement, but, you know, we're just going to go through the two things that all attorneys should ask themselves when writing their opening. There are two simple tests to determine whether something should be said in an opening statement. The first is the 3-question test, which requires us to ask ourselves the following when considering what to say in an opening statement. Will what we say be remembered? Will what we say assist in understanding the factual issues? And will what we say assist in setting the scene? That's it. That's test number 1. Test number 2 is the fact test. The fact test determines whether a piece of data meets the requirement to be classified as fact. If a witness can say something on the witness stand, or if a document or some other form of evidence can provide the information, then it is fact, and we can use it in the opening statement. Again, with regards to, we can prove to you how she was killed, where she was killed, and when she was killed. These are 3 things that Kratz could not prove. There is no evidence that proves this beyond a reasonable doubt. There is no scientific evidence with any 100% scientific degree of certainty that proves that those are Teresa Halbach's remains. There is no scientific proof that she was killed, beaten, raped, or stabbed, let alone in Stephen Avery's trailer or in his garage. There is no factual scientific evidence that she died on October 31st of 2005. And there is no scientific fact that she was killed by a gunshot wound. There's none. And yet all of those statements were included not only in Kratz's opening statement, that's his whole fucking case. So I want you guys to think on that. I'm going to leave the link for a couple of sources on opening statements down below in the description so that you guys can check it out for yourselves, because after all, that's what we're doing here. We're educating the masses. I will also leave the link for the GoFundMe campaign for Clue TV. Thank you all very much for watching, and we'll see you soon.